Indigenous People of Biafra, IPOB, has said that the detained Biafra Republic agitation leader, Mazi Nnamdi Kanu, has not forfeited his rights to defend himself before the Federal High Court sitting in Abuja, after the judge, Justice James Omotosho, ruled on Friday and stated that Nnamdi Kanu's rights to enter defense has been forfeited and thereafter fixed November 20, 2025 for judgment, as Nnamdi Kanu was seen to have staged a defensive confrontation with aggressive loud voice, challenging the court that the federal government allegations against him has no legal basis or any aspect of the Nigerian law that backs such allegations. This, Barrister Aloy Ejimakor, the organizing lawyer for the detained Biafra Republic agitation leader, had on Wednesday said in a written and video statement posted on his X social media account that Nnamdi Kanu is competent enough to defend himself, especially given the political elements in the case which he understands better than any lawyer. In a press release issued and made available on Friday, IPOB, in the statement signed by Emma Powerful, said it strongly condemns the new round of fake news being pushed by certain Nigerian media outlets. The false claim that Mazi Nnamdi Kanu has forfeited his right to defense in the ongoing trial before Justice James Kolawole Omotosho of the Federal High Court, Abuja, is a desperate lie meant to mislead the public and cover up an illegal process. Let the truth be clear: Mazi Nnamdi Kanu has not forfeited anything. What is happening in court is not a fair trial but a political show. Up till today, neither Justice Omotosho nor Chief Adegboyegba San, the government's lead prosecutor, has been able to point to any valid, existing law that Mazi Nnamdi Kanu supposedly broke. Their silence speaks volumes. It is a quiet confession that this entire case has no legal foundation. The core question remains simple: can anyone be prosecuted or convicted without a living law that clearly defines the offense and prescribes a punishment? The answer is written in Section 36(12) of Nigeria's 1999 Constitution. A person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law. This means you cannot charge or convict anyone unless the law exists in black and white. No judge or lawyer can twist that. The Supreme Court has said the same thing many times. In Auko vs. Fagbemi, 1961, AG Federation vs. Abubakar, 2007, and NNPC vs. Fawahinmi, 1998. Where there is no law, there can be no trial, no conviction, and no justice. But instead of obeying this clear rule, Justice Omotosho keeps trying to force Mazi Nnamdi Kanu to open his defense, as if pretending there's a valid case will make it real. This is wrong. It's a misuse of power and a clear violation of fair hearing. You cannot force a man to defend himself against a ghost charge. So we ask again, under which law is Mazi Nnamdi Kanu being tried? What act of the National Assembly defines his supposed offense?